Today, I borrow another point from attorney Rita M. There are numerous redundant safeguards on an Article 5 convention process. Attorney Peters lays out 4 safeguards. Okay, number 1, the scope of authority for the convention is defined by the topic specified in the 34 applications that trigger the convention. Any proposals beyond that scope would be out of order, and any single delegate could object to their consideration. Number 2, even if no one objected to an out-of-order proposal, and/or even if the convention delegates had installed a parliamentarian who refused to sustain an objection, state legislatures can recall any delegates who exceed their authority or instructions. This is because convention delegates are the agents of their state legislature. That's a legal term. They are agents of the legislature, and they are subject to the instructions given by their legislature. As a matter of basic agency law, any actions taken outside the scope of a delegate's authority would be null and void. Number 3, even if a majority of convention delegates went rogue and state legislatures failed to stop delegates from acting beyond their powers, and Congress nevertheless sent the illicit amendment proposals to the states for ratification, the courts would declare the proposals null and void. And the courts have an excellent track record of enforcing clear technical matters of procedure and law. Fourth and finally, even if all those protections failed, it borders on insanity to think that 38 states, the requirement for ratification, to think that 38 states would ratify an amendment proposed under these circumstances borders on insanity. And so I repeat attorney Rita M. Peters' point, there are numerous and redundant safeguards on the Article 5 convention process.